Okay, so it's time for chapter 4. We're moving right along, and this chapter deals with the medical, legal, and ethical issues involved in EMS. Once again, we're on page 78 and starting with 79. I want you to be sure you know and understand key terms in this chapter. So if you look on page 79, there's abandonment, advance directive, assault, and battery, and all of the pages that you'll find all of those terms under. So be sure you understand what those terms are. First thing we're going to talk about is the scope of practice. The scope of practice is regulations and ethical considerations that defines the scope or the extents and limits of an EMT job. These might include skills and procedures and medical interventions that the EMT might perform. So what it is you're going to do to help the patient. This is defined by legislation, and this can vary from state to state. Sometimes, and this happens to be the case in Illinois, different regions within the same state may differentiate rules and guidelines for their EMTs. So your scope of practice is determined by national, state, local laws, statutes, and sometimes even protocols. The next term you want to know and understand is the standard of care. The standard of care would be what is expected from you, or as an EMT, what would somebody that you're going to help, what type of care would they expect? And all EMTs have similar training because they're covered by the National Education Standards. And remember, that comes down from the Department of Transportation under the National Highway Traffic Safety Administration. They help develop that curriculum and that basic standard of care. So if you meet standard of care, this is going to reduce the risk of any legal action against you. So you can differentiate your scope of practice from the standard of care by the fact that scope of practice is what you can do. The standard of care is how you should do it.
Legal issues are a reality for healthcare workers. For many years, even centuries, the decision of the physician or the healthcare professional was unquestioned. This has changed. Healthcare consumers and patients have become more aware, more critical, and much more willing to sue anyone that their lawyer believes has been at fault, including phlebotomists. To grasp the legal implications of healthcare, all healthcare providers must have some knowledge of basic legal terminology. Negligence is a violation of a duty to exercise reasonable skill and care in performing a task. Malpractice, or professional negligence, is defined as improper or unskillful care of a patient by a member of the healthcare team or any professional misconduct or an unreasonable lack of skill. For example, say a phlebotomist didn't thoroughly cleanse a patient's finger before performing a finger stick. Even this simple mistake could lead to a lawsuit if the site became infected and caused harm to the patient. The laboratory medical director, in most cases, is responsible under the law for the standard of care and the performance of all aspects of laboratory testing. A breach of standards on the part of the healthcare worker collecting blood could place both the medical director and the healthcare worker at risk from a lawsuit. All healthcare workers must conform to a specific standard of care to protect patients. The standard can be thought of as a measuring stick representing the conduct of the average healthcare worker in the community. If a patient has suffered injury due to a blood collection procedure for laboratory testing, the patient must show that the healthcare worker who collected the blood failed to meet the prevailing standard of care. Access to patients' medical information is regulated by the Federal Health Insurance Portability and Accountability Act, or HIPAA. HIPAA requires that healthcare providers obtain a patient's written consent before disclosing medical information for the routine uses of diagnosis, treatment, payment, or healthcare operations. Thus, each laboratory must give patients information on their rights and on the ways their laboratory test results will be used. Healthcare workers must review and sign a confidentiality and non-disclosure agreement that describes the sensitivity of patient information. Negligence cases can arise out of violations of the right to privacy or patient confidentiality. No one except the patient may release patient results without a clinical need to know. Confidential materials include communications between the physician and the patient's verbal statements, medical computer entries on patients, and nonverbal communications such as laboratory test results. The safest rule of thumb is never talk about a patient unless it is essential for the care of the patient. Don't share stories about patients with coworkers or friends. Don't discuss patients in areas where you can be overheard by the public, and always keep test results private. Informed consent provides voluntary permission by a patient to allow touching, examination, and/or treatment by healthcare providers. An informed consent form is signed by a patient for approval of medical treatment, including blood collection. It allows patients to determine what will be performed on or to their bodies. Without informed consent, intentional touching can be considered a criminal offense. Minors must have the informed consent of their parents or legal guardians for medical care, including blood collections. Persons who are unconscious or injured in such a way that they are unable to give consent must have consent provided from the closest adult relative if existing laws permit. Since language can be a barrier to informed consent, an interpreter may be necessary so that information for consent may be given in the native tongue. Implied consent occurs when the patient's nonverbal behavior indicates agreement. For example, a patient who holds out or positions his or her arm for venipuncture is implying their consent to the procedure. Implied consent also exists when immediate action is required to save a patient's life or to prevent permanent impairment of the patient's health. In other words, a medical emergency removes the need for consent. Implied consent differs legally from one state to another, and healthcare providers need to know the legal boundaries of implied consent in the state in which they work. The statute of limitations is a law that defines how soon after an injury a plaintiff must file a lawsuit or be forever barred from doing so. This law prevents the threat of a lawsuit from extending over a long period of time, thus hanging over a possible defendant's head for years. Respondeat superior, a Latin term meaning let the master answer, is a legal doctrine that holds employers responsible for acts of their employees within the scope of the employment relationship. Not only may an injured party sue the employee directly, but the employer as well. The employer, if sued, may also seek indemnification from the employee. Indemnification is compensation for the financial loss suffered from the employee's act. Justice is expensive in the United States. Lawyers' fees typically range from $200 to $700 per hour, and associated costs can lead to thousands of dollars in legal fees. Legal proceedings are time-consuming, expensive, and most of all, emotionally devastating to both the plaintiffs and defendants. Phlebotomists must be familiar with common-sense guidelines that will help them to avoid lawsuits. These include documentation. Always document the time, date, and blood collector's initials on the blood collection containers. Honest, accurate reporting of incidents. If an adverse incident occurs to the patient and/or the blood collector before, during, or after blood collection, report the incident truthfully to your immediate supervisor and complete the appropriate documentation in a legible manner. Following facility procedures. Always follow your healthcare facility's specific procedures. If you must deviate from a policy or a procedure, discuss the incident with your immediate supervisor and decide on the appropriate action. Ensure patient safety. Failure to do so can have legal ramifications. Ensuring patient safety could include monitoring the patient in an appropriate, timely manner during and after blood collection, returning bed rails to the raised position if the bed rails were raised prior to blood collection, securing the patient in the blood collection chair for the duration of the blood collection procedure. Ask each patient if he or she has a tendency to faint at the sight of blood. If an ambulatory clinic patient says that he or she might faint or does faint during blood collection, place the patient in a supine position to collect blood and monitor the patient for at least 20 minutes after collection before allowing him or her to stand up and leave the facility. Safety considerations also include removing all supplies and equipment after the procedure. Another issue is proper treatment and performance. This heading includes use proper technique and equipment, for example, gloves, when performing procedures. Update your collection skills and techniques through continuing education classes or exercises that have required documentation of attendance. Maintain up-to-date performance evaluations that are well documented by the supervisor with any corrective action. Report any significant changes in a patient's condition, for example, if the patient continues to bleed from the puncture site after blood collection. Equipment use. Learn how to use blood collection equipment as designed. Use biohazardous waste containers as indicated in procedures. If involved in off-site blood collections, carry biohazardous waste containers with you. Phlebotomists involved in off-site collections should also have the correct types and amounts of insurance coverage to address liability exposures with respect to transporting biohazardous specimens. Also, be conscious of actions that could result in a lawsuit when working with patients with HIV. Avoid discrimination in treatment. Guard against transmission of the virus. Avoid a breach of confidentiality. And always follow your healthcare facility's procedures for blood collection and disposal of biohazardous waste. Some problems associated with phlebotomy that have led to lawsuits in the past include patient falls during or after venipunctures, hematoma hemorrhage from inadequate pressure to the vein, abscess or other infections at the venipuncture site, injuries from fainting before, during, or after blood collection, nerve damage due to poor venipuncture technique, complications from collecting blood from the same side as a mastectomy, identification errors leading to the wrong diagnosis or treatment causing injury or death in some cases. Lawsuits are an unfortunate reality in the modern world, but by taking appropriate steps, you can help your healthcare team reduce the impact they have on your facility.
A lot of those suggestions can apply to EMTs in their profession as well. So one of the things you first want to do is make sure you have appropriate patient consent and refusal. So patient consent results from permission that the patient gives you to assess, treat, and transport them. Generally, you want this to be expressed consent. That means they say, okay, I would like you to help me. You need to go and inform them who you are and what you're there for and ask them if that's okay. And they will say yes if they want your treatment. So, hello, my name is Vicki. I'm an EMT. I'm here to help you. Is that okay? And express consent would be that they nod their head yes or they say yes. Now, one of the things you want to make sure of is that they have an informed consent. An informed consent is that the patient understands the risks associated with the care that they will receive. It's not always a legal requirement but it's good, sound emotional care to explain all the procedures to the patient so that they know what's going on, and it builds a good trust and good rapport with you and your patient. Implied consent It's used when a person cannot give consent for themselves. That's how this term applies to EMS. So you might have a patient that is unconscious, or they're physically or mentally incapable of saying yes, and they need emergency care. Then the law states that rational patients would consent to treatment if they were conscious, and this is known as implied consent. And then you sometimes have to get consent from children or mentally incompetent adults who cannot legally give consent on their own. And uh, you there's a couple of different ways that this can happen. Number one, minors can't legally permit to provide consent or refusal, either one. And you have to get it from a parent or guardian. But if the kid is at school, then the school authority, or if they're at daycare, the daycare provider might have this. They are acting in what's called in loco parentis, and that means in place of a parent. So when the parents aren't physically present, there might be somebody that can um, act in place of the parent, in loco parentis. Parents in this situation may provide written documentation to those individuals, and it allows them to act in their absence. And then there's the situation of emancipated minors. Um, Kids, teenagers that may have may have either legally or by default not be in their home anymore. If they're married or if they're of a certain age, then they can provide consent. Or if they are a minor, maybe a 16-year-old girl who has a child, and uh, then they also are responsible for their own consent. There's also the case, too, um, that you may have a child that has a life-threatening injury. For instance, they have cut themselves very badly and they're bleeding, they're hemorrhaging. This is a life-threatening situation, and if you can't find a parent, a guardian, or anybody else, then you can legally give consent or give care to that minor based on the fact that it's a life-threatening condition. And this is similar to implied consent. So, some exceptions to children and mentally incompetent adults: if they have a life-threatening illness or injury, then they then you can give care, or if they have children of their own, or if they're serving in the armed forces, then they can give their own consent. Sometimes you have adult patients that are incapable of informed decisions about their care. They don't quite understand and may not want to give you consult. Maybe they're mentally incompetent. Then some states and some local laws and protocols will permit you to transport these patients under the assumption of implied consent. When in doubt, you're always better to provide care rather than withhold it. It's a safer alternative. So you can't transport somebody involuntarily generally. The only times that you could do that is if the patient is considered a threat to himself or others, or if you have a court order, or the police have arrested him or requested physical transport. And in these cases, they actually might request that you restrain a patient. This is a very high risk legal liability to you. So lots of lawsuits can actually come against you alleging negligence. And these lawsuits are brought against EMS providers for improperly restraining or causing harm to patients during transport. So, whenever you restrain somebody, you are denying the ability of them to move freely. And that is a huge responsibility to take on. You still have to be very vigilant in maintaining their health and well-being while they're restrained. So, you want to frequently and thoroughly monitor the patient's mental status and vital signs while you care for the patient. A good reference, not only does it say it on page 81 in your book, you want to look at page 628 and 629, and it talks about reasonable force and restraint and what the law sees. In most places, an EMT cannot legally restrain a patient. You can't do this against their will or force them to accept emergency care. That's in most places. The police, and sometimes in some places a physician, can order you to restrain and transport a patient to an appropriate medical facility. Um, and that's only if you don't cause danger to yourself. In these cases, you want to be sure you can safely restrain the patient, and you want to use soft restraints, not little zip ties or handcuffs or anything like that. So, and the other thing is you want to make sure that you have a backup, uh, somebody that agrees with the fact that this patient needs to be restrained. So you need to have witnesses and good documentation in order to fully restrain somebody. Patients can refuse care, though, generally as a rule. And if you have a patient refusal, refusals are high liability. Once again, one of the most common causes of lawsuits is from patient refusals, and the second highest, or maybe they're similarly the highest, but the two highest causes are patient refusals and ambulance accidents. So a patient can generally refuse care, but you need to make sure it follows the rules as far as refusal. First of all, they have to be legally able to consent. They have to be competent adults. They need to be awake and oriented, and then they must be fully informed. That means they need to know the risks and the benefits of them either accepting or refusing that care. And then in the very end, they'll be asked to sign a release form saying that they understand and they don't hold you liability. But even with all of this, sometimes you may still be held liable. So you want to be very careful in refusals to make sure that, number one, they're the right age and that they're awake and alert and oriented and they don't have impaired judgment and that they're fully informed, and then they sign the release. One of the best things you can do for a patient that refuses care is take all possible actions to persuade the patient to accept that care and transport. So speak with them, find out why it is that they're trying to refuse care. Sometimes it's for the simple fact that they don't want to leave their animal home. There's nobody to care for it, or something simple. And you might be able to work through those things that are holding them back and find solutions so that they can actually get the care that they need. So listen to your patient. This is the key to determining why they are refusing care. And then be sure and inform the patient of the consequences of not going to the hospital. Some ways you can thoroughly persuade them is you could actually call medical direction, and the doctor online might be willing to help you to convince the patient to go. You might be able to call law enforcement. You might be able to ask family members to help in assisting you and convincing them to go. So, consult medical direction, ask family members, ask the patient if it is all right if you call a family member. You don't want to, of course, overstep your bounds as far as confidentiality, but this might be a way to help alleviate the person's anxiety about going to the hospital. Call law enforcement personnel if necessary. If they are not legally competent, they've maybe been drinking and they're intoxicated and they don't understand the risks and benefits, you might have to call law enforcement to help you convince them to go to the hospital. So, what are the risks of beginning treatment and or transport without getting consent from the patient? Well, one of the things they could um, do is if they could claim that you uh, assaulted them. And so good consent would help alleviate that possibility. And what if the patient refuses to sign the refusal of the form? Let's say that they've met all the criteria to refuse, but they just don't want to sign a refusal form. Well, if that's the case, you need to document that and get a witness and document that they won't sign. Subjecting the patient to unwanted care and transport has actually been viewed in court as assault and battery. So have witnesses to your refusal. Inform the patient that they can change their mind and that they can call back at any time. If possible, have a friend or relative remain with the patient and document everything that you said and did and all of your attempts to get them to go very thoroughly. Now, some other things that you might run into is something called a do not resuscitate order, DNR order, or in some states there's another thing called a POST, physician orders for life-sustaining treatment. These are forms of advanced directives. Look on page 83. What is an advanced directive? An advanced directive is instructions written in advance of an event about what they want to do. A DNR order is one form of an advance directive. The other type of advance directive that sometimes people like to talk about is called a living will. A living will differs from a DNR order in that a living will just states that the person does not want to be placed on life-sustaining measures, life-sustaining treatments like a ventilator or something. But since you don't do that as an EMT, then you're more apt to respond to what's called a do not resuscitate order, where you wouldn't provide CPR or try to resuscitate them. But a DNR is part of an advance directive, or it may be part of a physician order for life-sustaining treatment or a POST form. So be familiar with all types of living wills and healthcare proxies. A healthcare proxy is somebody that's going to speak for the patient, a family member or something that has power of attorney. Other legal issues that you might come in contact with. Negligence. Negligence is something that should have been done and it was not done. And anybody in this world nowadays can sue somebody else for something. So the EMS profession is not any different in that way. But the law kind of helps us out in that you have to prove a number of things in order for an EMT to be successfully sued by somebody. First of all, they have to prove that the EMT had a duty to act. Now, if you understand when you do or do not have a duty to act, then you will be able to avoid problems and being sued for negligence. So a duty to act is an obligation to provide emergency care. What type of EMT has an obligation to provide emergency care? Well, one who's working on an ambulance and dispatched to a call clearly has a duty to act and provide care. If you're not on duty, it's kind of debatable whether you have a legal duty to act, and that varies from states to states. In some states, an off-duty EMT has no legal obligation to provide care, but some of them say that you do. But even if you're off duty as an EMT, if you stop and you start to help somebody, then you have established a duty to act. Now, that's the first thing that must be proved. Second thing is, did you breach that duty? So did the EMT fail to provide a standard of care expected, or did they not act when they had a duty to do so? And then the next thing that needs to be proved is something called proximate cause. Proximate cause is is means that that the patient suffered some type of physical or emotional harm because the EMT did not act appropriately. They refused to act, or they did not do what they were trained to do. So, if they find those things in the court, if you get sued, then you would be found to be negligent. But it's kind of hard to prove all of those things, so most of the time, lawsuits are unsuccessful against EMTs who have followed those rules. Res ipsa loquitur, that means the thing speaks for itself. This is a legal concept important in negligent cases. It's a Latin term. This is a foundational concept in negligence. It allows the finding of negligence even if there's no specific evidence of the fact. So, if you had a patient that was dropped, for example, they were on a stretcher and they were dropped, and the patient was injured because the EMT had exclusive control over the stretcher when it was dropped. There's a reasonable assumption that the EMT caused the accident and that some sort of negligence happened, or the accident would not have happened. So, understanding if you have a duty to act. This is an obligation to provide care to a patient. The duty to act isn't always clear, especially if you're off duty, or sometimes if you're on duty, but you're not in your jurisdiction. For instance, if you took a patient to Iowa City and then you were coming back from that long transfer and you're in Henry County and you saw an accident, you are technically out of your jurisdiction, so you do not have a duty to act. Now, morally and ethically, it's kind of not a good thing for an ambulance to drive by an accident, unless of course they have a patient on board. Then they would totally not be able to stop because they're currently in business. But a duty to act there can be kind of shady if you're off duty or if you're out of your jurisdiction with no patient. But follow local laws and protocols and do what's best on your conscience. That's always the best thing. Try to do the right thing morally and legally. Abandonment. Once you initiate care, you cannot stop or discontinue that care until you transfer that patient to somebody similarly trained of equal or greater training. So that means if you've started care on somebody, you need to turn that care over to another EMT or a paramedic or a nurse or somebody with higher level training than EMT level. Failure to do so can be considered abandonment. Good Samaritan laws Every state has Good Samaritan law. They vary just a little bit, but pretty much they say that if a rescuer acts in good faith within the level of their training, and if they're not being compensated financially, then you are covered from legal responsibility. It might not cover EMTs in all situations, just depends on whether you're on duty or have a duty to act. Um, and it doesn't really protect people from gross negligence or if they are violating the law, but most Good Samaritan laws uh, cover people as long as you're not doing any of those things. So you arrive at the scene of a patient in cardiac arrest. The family says that she has a DNR but don't know where it is. How would you handle this? So the DNR is a do not resuscitate order. Patient does not want any resuscitation to be started. Um, in this case, you need to find the physical documentation because you can't always believe that that's the case if a family member says so. But most people with DNRs have them and know where they're at. And some of them have even given them to local EMS so that they know ahead of time. But you want to definitely verify that it is true that they do not have, or they do or do not have a DNR order. So ask for documentation, but when in doubt, you're always safer to start CPR as opposed to not start it. So you're off duty and you arrive on the scene of a vehicle crash. Police and EMS have not yet arrived. Are you legally obligated to stop and render aid? In most cases, no, not if you're off duty. You don't have a legal obligation to stop and render aid. But as an EMT, I would kind of throw out to you that maybe you have a moral or ethical obligation to provide care. You're somebody that's trained and knows what to do in situations like this, and it's really not very nice to drive by somebody that needs help when you know that you can be one to help. So morally, it's your own personal standards, your own principles of right or wrong. Ethically, socially, or any social or professional expectations for applying these principles of right or wrong. In that case, you probably better to stop and provide that. It's the right thing to do. Are you legally obligated to do it? Probably not if you're off duty. Confidentiality. This is another thing that EMTs need to be aware of, and that there are laws. Confidentiality, the obligation not to reveal information obtained about a patient except to another healthcare professional that's involved in their care. You cannot give information about your patients to anybody that does not have a need to know. And HIPAA, HIPAA, this is the Health Insurance Portability and Accountability Act. This is a legal obligation to for you to not talk about your patient to anybody. And this can cause lots of financial fines and legal liability if you do not follow HIPAA laws. So information shared with other healthcare personnel are part of the patient's continuing care. So if you're turning your patient care over at the hospital, those people have the need to know. So you can give them a patient report about your patient's information. But otherwise, the only way you can give that to anybody else is if they obtain a subpoena through the court. Medical identification devices, we need to be looking for those when we give or when we go and respond to patients that might not be able to tell us whether or not they have allergies. So you could have people that have those because they have heart conditions or allergies. Commonly, they're for people that have diabetes or epilepsy, and they alert EMTs if they find somebody that's unconscious. They alert the EMTs of what could possibly be wrong with them. Uh, so medical identification devices might be in the form of a necklace, a bracelet, or even a card. People a lot of times talk about them having them tattooed on themselves somewhere, but I personally have never ran into anybody that's got a tattoo. Organ donation. You might run into people that have an organ donation card. It's a legal document allowing donation of organs and tissues in the event of death. Most of the time, EMTs don't have to respond to this. They're out of our scope. But if you do know that that's the case, you can pass that along to medical direction um, so that they can be aware if they are happen to be resuscitating that person that they can help keep the organs perfused until they can be salvaged and donated as the patient requests. Another law, and this is one that does apply in Illinois for sure, is a safe haven law. In this law, a person can drop off an infant or a child at any police, fire, or EMS station, or deliver the infant or child to any available public safety personnel. So, this has helped to eliminate the people that are just dropping infants and babies into trash cans and leaving them to die. The law does state it has to be a manned fire or EMS station. Okay, but they can drop off their child if they don't have any, place that they just can't take it any longer, and then they can that child is at least in a safe place and can be turned over for child uh, foster care. This protects children who may otherwise be abandoned or harmed by parents unwilling or unable to care for them. Crime scenes. A lot of times EMS people are called to crime scenes, and sometimes they're called there before the police are. And this is scene safety is our priority. So you need to make your safety number one. And so when you are dispatched to a crime scene, don't approach the scene until you've decided that it's been safe to do so. And that's usually after the police have made the scene safe. Once you're there, know what evidence is and take steps to preserve evidence. Don't cut through clothing that have bullet holes in it. Don't cut through the bullet holes. Just simple measures. Watch where you step. Don't walk on footprints and scuffle them all up. Some examples of evidence might be the condition of the scene, the patient, how they laid. If you move something at the scene, don't be aware of that you moved it and document it when they tried to put the scene back together and figure out what happened. Fingerprints and footprints, be careful of what you touch, where you walk, and then any microscopic evidence that might be on the scene. Remember what you touch, minimize your impact on the scene. If you're forced to move the patient or furniture to begin care, move as little as possible. Try not to use the phone, or they can redial it if they thought somebody used the phone there. Don't use the bathroom. This might destroy evidence. Of course, you shouldn't be using the bathroom when you're on a call anyway. And then work with the police in preserving that and provide statements and give them information that can help them rebuild the crime scene. Other special reporting requirements might be if there's a child, elderly, or domestic abuse. You can call hotlines, and in Illinois, it is required that you report child abuse. If there's violence, gunshot wounds or stabbings, sexual assault, situations where you might need to restrain the patient, and remember, look at page 628 to be thoroughly familiar with when you should or should not restrain people. Intoxicated persons with injuries, whether or not they have the right to refuse. Mentally incompetent people with injuries, and just make sure that you're following your local protocols. And most generally, that is to favor the patient and to provide that care. So, in review, medical, legal, and ethical issues are part of every EMS call. It's something you need to continually think about. You need to make sure you have consent, expressed consent or implied consent, following the implied consent rules. If a patient is awake and oriented and has the capacity to fully understand his situation and he wants to refuse care, you should make every effort to persuade him, but you can't force people to accept care or go to the hospital, and in that case, have him sign a refusal. Negligence is failing to act properly when you have a duty to act. As an EMT, you have a duty to act whenever you are dispatched on a call. You may have a legal or moral duty to act even if you're off duty or outside your jurisdiction. Abandonment is leaving a patient after you have initiated care and before you have transferred the patient to a person with equal or higher training. And confidentiality is the obligation not to reveal personal information you obtain about a patient except to other healthcare professionals involved in the patient's care under court order or when the patient signs a release. As an EMT, you can be sued or held legally liable on any of these issues. However, EMTs are rarely held liable when they have acted within their scope of practice and according to the standard of care and have carefully documented the details of the call. At a crime scene, care of the patient takes precedence over preservation of evidence. However, you should make every effort not to disturb the scene unnecessarily and to report your actions and observations to the police. EMTs must use good judgment and decision-making skills when dealing with patient consent and refusal. Avoid negligence, and that implies using good judgment. Critical thinking is an essential component for avoiding liability. EMTs hold responsibility for patients' protected health information. Exercise care when dealing with this information is a legal and ethical obligation of yours. Define scope of practice, negligence, duty to act, abandonment, and confidentiality. Remember, review your terminology at the beginning of the chapter. Understand those terms. Understand what steps you need to take when a patient refuses care or transportation. Think about the evidence that you might come in contact with at a crime scene and how you can act to preserve that evidence. Read the situations in your book. There's critical thinking in your book that you can review to help you understand when a situation like that might arise. So you respond to a motor vehicle crash and you find a seriously injured patient. He has no pulse, and you're about to begin CPR when someone says, "Don't do that. He's got cancer and a DNR." No one has the DNR at the scene. Do you start CPR and transport the patient? Well, of course you do. He isn't dying from cancer at that moment. He's dying from an unforeseen tragedy. So you can't rely on the fact that he did not want to be resuscitated. And how do you know that that's even a true statement? A lot of people have a lot of gossiping that goes around and stories change. So to be on the safe side, you start CPR.